Hey guys, welcome to the Fab Attorney on the docket. Oh my goodness, I have not done this in so long. During the pandemic, my name is Fab. I'm an attorney. I've been an attorney for over a decade. I'm a trial attorney. I've practiced in New York and in the state of Florida. And today, I had my team pull some cases of interest to see what the YouTube streets are talking about. And we are going to be watching or reacting to a video of an Ohio teacher, and she was stalking her boyfriend. She pled guilty to that, and the judge rejected the deal. I think this gives a lot of people a lot of anxiety. This is a very typical thing that sort of happens depending on the judge. So how I'm going to do it is just go ahead and start playing the video and giving you guys my thoughts and my commentary on it. I plan to be streaming in the YouTube streets 3 times a week. And so this is my, breakout video. And let's just jump right into it.
Okay, let's go on the record. We're here on state versus Hannah Freeman. Ms. Freeman is here on case 697-119.
So let me set the scene up for you guys. Typically, well, let me tell you a little bit about the case. So this case is a spicy one. A former North Ohio, I'll just say Ohio because I don't want to butcher the name. Ohio fourth grade teacher Hannah Freeman accused of stalking her boyfriend. Everybody agrees that they were in like a super toxic relationship, and she pled guilty. So she admits these facts, that she followed her former boyfriend to his place of work, also a teacher, on 33 occasions in less than 3 weeks. And some other things like stealing drugs and, damaging property. She was accused of 4 felonies, and her attorney ultimately was able to get 1 thrown out and 3 reduced to misdemeanors. And she pled out to the misdemeanors. So how this would work is that the defense attorney would speak with the prosecutor. They'd go back and forward, perhaps getting, letters of character, perhaps psychological reports, the like. And I don't believe Hannah has a criminal history, things of that nature. And then ultimately, both the prosecutor and defense attorney agreed that a non-jail sentence with other conditions were appropriate. And once that's agreed to, the hearing is scheduled to go before the judge, where the plea is presented to the judge, and the judge usually accepts it or can reject it and give his own sentence that he believes is just. So that's sort of what we're seeing playing out here. Let's get back to it.
She's here with her lawyer, Michael Kinlan. Assistant County Prosecutor Patrick White is here for Brandon Pateo, who is in trial in another courtroom. Ms. Freeman pled guilty back in June to disorderly conduct, a minor misdemeanor in count 1, obstructing official business.
Not to stop and start too much, but catch that, T. So the defense attorney and the accused are there. There is another prosecutor who was not the assigned prosecutor standing in for the other prosecutor who's on trial on another matter. That might come into play. Let's see.
A second-degree misdemeanor in count 2 in Possessing criminal tools, a first-degree misdemeanor. In count 3, she was referred for a pre-sentence investigation, which the court has received and reviewed. PSI is extremely detailed.
Atera is the IT painkiller, remote monitoring and management.
Okay. So, guys, the pretrial statement is something that is prepared, giving a social background, educational background, psychological background. If there are any priors, that's given to the judge. And as like mitigating factors, either from the prosecutor standpoint of saying, hey, this person has done this type of thing before and they're a danger to the community, or from the defense perspective, any mitigating factors, any childhood traumas, anything like that that might be mitigating to the judge. It's in a like a voluminous, robust report for the judge to read and consider with sentencing. And I'm sorry, guys, you're going to have to deal with the commercials. I guess I have to get the premium version.
Remote access, help desk and ticketing, smart automations, patching, software deployment, script.
Counsel, have you read the PSI?
Yes, I have.
Yes, Your Honor.
You find it to be complete and accurate?
I do, Your Honor.
I find to be complete, some of the police report was not accurate, hence the reason for the amended charges.
In what way?
We provided text that showed that the alleged victim had lied about the stalking and some of the other issues.
Well, what part of this document is not accurate?
Just where it relates to the police report.
Pardon me?
Just where it relates to the police report.
I don't understand what you're telling me. There's 4 single-space type pages that looks to be largely taken from the police report. Are you telling me the entire PSI is inaccurate?
No, just where the alleged victim told the officers that she was stalking him. They were still engaged in a relationship at the time. She had planned on spending the night at his house that night with his permission. It's not much.
How about the flock camera part on the bottom of page 2, where flock camera plate readers showed your client's vehicle to be on Westlake City School properties 33 times on 19 different days over the past 30 days, up to and including November 7th at 4:07 p.m.
That is accurate.
Okay.
He had invited her there. She was there.
He invited her to school
Yes.
30 times.
Yes.
Mr. White, do you know anything about this?
Your Honor, what the state could say at this time is that the defendant on occasions over this period did.
What I can say is I can kind of tell, former criminal defense attorney here, the judge isn't feeling it. It seems like he's being, a little nitpicky on the details, and he's highlighting the details, or he's trying to bootstrap highlighting certain details that paint the Miss Freeman in a more dangerous, facetious light. It's never a good sign.
In fact, invite the the victim did invite the defendant, but the state will contend that the defendant was there and her continual presence across this time did cause the defendant continual anguish and mental stress.
Is there a dispute over whether she took his property?
No, Your Honor.
No, there's no dispute over that, Your Honor.
Why did your office have her plead to theft? I know this wasn't your case, but I'm here dealing with the confusion. What happened?
Your Honor, in this case, the defendant and the victim were engaged in a relationship. They broke up over the pursuing months. the defendant did not get the realization this relationship was over. At different times, she did steal numerous.
Again, the fact that the prosecutor who is the actual assigned prosecutor to trial plays out here, because this prosecutor, you can tell he's not familiar with the case, and he keeps on referring to his laptop, and he's trying his best to sort of stand on his feet. But I think the most important thing is that the judge is not feeling it. He wants to know why Miss Freeman didn't plead to an additional charge. And again, he's sort of highlighting things that wouldn't be to her benefit or to her favor. It seems like he is not feeling, from the tone of this, obviously we already know the end, the plea deal here.
Items from the victim in this case. Our office reviewed that. We did see those actions more as a continual pattern of conduct in order to get the victim back into her life.
You agree? Is that accurate?
And not including our.
And we can tell we stand in this county, Mr. Killen.
Yeah, sure. It's our opinion, and the facts would have shown if we would have went to trial. She did take his book bag for about 3 minutes.
Oh, did you guys catch that? The judge said to the defense attorney, "We tend to stand in this county, Your Honor." I mean, whatever his last name is, the defense attorney. So this is not a attorney that goes before this judge or is familiar with this county. So maybe a little hometowning is happening, and hometowning is a little bit of hazing when you sort of don't know the local judge's ways and you haven't done your homework. And the judge is going to highlight the fact that you didn't do your homework, which is not going to be something that's positive for your client or for yourself, as you guys are going to see play out here.
By return it, she only took it once she found another girl at his apartment. She was on her way to spend the night there that night. They had agreed on it. She went over there, and then he texted her, told her not to come, and she realized he had nothing over there. She got mad, went in this car, took the book bag, only as a means to get him to talk to her, and then she tried to return the book bag 5 minutes later, and that's when he called the police.
Okay, I'm led to believe by the pre-sentence investigation that this relationship between the alleged victim and Ms. Freeman ended in April of 2024. Is that correct?
That is not correct. It ended on November 6th, 2024. And that's why if you review the discovery that I provided, the text detail everything. And that's why we had negotiated plea with the charges that we have and that she pled guilty to.
Okay, the pre-sentence investigation indicates that your client took 2 backpacks, a red and a black backpack containing a Chromebook, laptop computer, an HP.
What I will say is what would have probably rubbed the judge a better way, the right way, is sort of throwing yourself on the sword and radically just saying, listen, my client has little mental health issues. We're getting her the help. She's so sorry. She did everything. Some judges, when they don't feel like there's a proper mea culpa or a full, you taking full responsibility, that's going to rub them the wrong way. And I can see that that's exactly what's happening here. They're sort of saying like the pre-sentence report is partially right and nitpicking, rightfully so, right? Hey, he invited her there. She took the backpack, but she was going to give it back 5 minutes later. And the judge is not feeling it. He's like, 30 times, 33 times. I mean, come on. So the judge is not feeling it. Sometimes you got to lay on the sword, so to speak, and go to the court and ask for forgiveness.
Laptop computer is the victim's wallet and a set of car keys to his car, apartment, and work school. Is that correct?
That's correct, Your Honor.
Don't mix pink salt with lemon and 2 other ingredients if you don't want to donate your entire wardrobe in less than a week. Don't believe me? Give me 60 seconds to explain. This is the pink salt trick that took me from 179 to 100.
I haven't seen any of these text messages. You haven't filed a sentencing brief or memorandum?
Well, they were in the discovery that I filed, the defendant's discovery.
Okay, Mr. White, what would the state like to present? Is there anything else?
Thank you, Your Honor. I will say for the record, the state is in compliance with Marcy's law in this matter. Your Honor, obviously this was a difficult situation. This was a toxic relationship. Over the period from April to November, this defendant engaged in conduct that was disturbing and concerning. And state believes there's a heightened concern because she was employed as a teacher at the time. We understand that the victim in this case did at points re-engage with the defendant over these months. But the state is comfortable with this plea offer after extensive conversations with and pretrial meetings with the defense counsel, because Ms. Freeman, and it's our opinion, has mental health issues that need to be addressed. I think that's evident from the PSI. I think that's evident from the facts in this case. We do understand that she has taken steps to do that, and as part of this plea, we did make it a condition for supervision in the form of community control, continued mental health treatment, and that is what we'll ask for at this time, Your Honor. Thank you.
Okay, Mr. Kinlan, what would you like the court to be aware of?
My client's 27 years old. She has a master's degree. She was previously employed as a 4th grade teacher. She lost that job as a result of this incident. She's got no other record other than a noise complaint from several years.
For me, I think this is a little bit slam bam. Thank you, ma'am. He's jumping up and he's sort of like throwing the words up there. To me, as a fine, no disrespect to this attorney, to me, you have to make your case because this judge is lukewarm on this at best. You have to really make your case. I think there's a little bit of a assumption going on here, and I think he's about to be humble based on, the headlines. I did read up on the case, but I haven't watched this full video. I'm watching with you guys.
Years ago, this is a negotiated plea based upon the facts and based also upon the negotiation that I did with my prosecutor's office. I believe it's a fair resolution. You're not going to see her back again. She was at the school numerous times helping him with his classwork. There was a principal discovery who I had subpoenaed in this case within the trial who would testify to that fact, that he talked to the victim and the victim told him no, she was there helping him. So there was no stalking in that regard.
He was invited. She was really stalking him. She was about to give him back the bag.
Heat of passion, when she found out he was still seeing this other girl, when she was supposed to be over there that night. She wasn't thinking, and did so in an emotional state. She is in mental health counseling. She regrets this incident, and I don't think you see her back here now. Thank you.
Okay, Ms. Freeman, you have the opportunity to speak before we announce your sentence. What would you like me to know?
I regret the incident. I definitely acted out of emotion, and I regret that decision that I made that night. And I will take steps necessary to move on from this incident, and you will not see me back here again.
Okay, thank you. Okay. Court has considered this matter. This is frankly a bizarro breakup between two professionals. The pre-sentence investigation does not paint a pretty picture of your behavior, Ms. Freeman. You should have known that was over. It's my understanding that the victim had someone else in his life. I'm going to place you on 18 months of community control. You'll be ordered to have no contact with Mr. McKenzie, the victim. In this case, as a condition of community control, you are to wear a GPS device for the first 90 days. You'll be on house arrest with work release. You'll be ordered to undergo mental health counseling, particularly to establish healthy boundaries. And you will serve the first 7 days of this term of probation in our county jail. You are ordered remanded.
We had agreed sentence.
You didn't agree with me, Mr. Kinlan, and I am charged with sentencing.
At this point, you are going to make a motion.
He told the judge we had an agreed sentencing. The judge is fully aware of that and is now letting him know I'm the one in charge of sentencing. The defense attorney seems taken aback, but what is common is that you go before a judge in like a case conference and you sort of ask the judge what their thoughts are on the plea prior to presenting it. Most judges, you have to know the judges will let you know what they're going to do. Some want to play coy, but it appears that didn't happen here.
Withdraw the plea. We'd rather go to trial.
Because you don't like the sentence?
No, because we don't like the way the court has interpreted the facts.
Mr. Kinlan,
Facts are not correct.
did you talk to me about sentence before you pled your client?
You were not available, Your Honor.
I'm available all the time, Mr. Kinlan. You chose to plead your sentence, your client.
We only met with you one time, Robert. At this point, we're asked to withdraw.
I'm offended that you would make the insinuation here that I don't work enough.
I'm not making that insinuation.
When was this case indicted?
December.
Yeah. It seems like a little bit of a personal vendetta at this point. In terms, I don't believe the defense attorney was insinuating the judge isn't work enough. However, he's a little out of pocket for insinuating that the judge was not available. It's not at this point. You're gonna have to take this up on appeal, and not this judge is not going to sway. So if you can look at this picture, this judge is playing no games. He's not happy.
Half a year ago. Did you make any effort to talk to me in the last 6 months about how I would sentence your client?
Yes.
No.
We did.
You did? When?
When I asked you to take her off GPS back in April.
Okay, and I did.
Yes.
But that wasn't about sentencing, was it? I just asked you, did you make any effort to talk to me about what sentence I would impose after you negotiated a plea deal with the state of Ohio?
No, we did have an agreed sentence from the state. We asked the court to go along with the agreed sentence.
You didn't ask me. Sorry.
Plea is not knowingly voluntary.
Your bad practice is not my problem.
I don't think it's my bad practice. We're done.
Yeah, the client wasn't prepped. Typically, before sentencing, you're going to prep your client. Hey, you're going to go in today. Make sure you leave all, your cell phones and these types of items with, loved ones. She wasn't prepared to go in. This is not a good look for the attorney. And obviously, it's an emotional scene. Yeah, a little bit into the nitty-gritty. He tried to withdraw the plea. You can't withdraw the plea. The defense attorney said that it wasn't knowing and intelligent. Yes, it was. She was allocated. She understood. They assumed the judge was going to go along with the negotiated plea deal, but it wasn't presented to the judge beforehand, and the judge decided not to go. But there seems to be a little hometowning going on here, and as a former defense attorney, my heart breaks for her, even though she's, obviously has some issues. You want everyone to be aware that they're going to do jail time. You want family to be aware. You want people to prep up their home, their economics, all the things line up prior to going into jail.
Yeah.
I saw
Listen.
comment and to her. Suppose she could. I don't know what he has done is reaches the level of malpractice, but it's definitely going to put a dent on his reputation in that community. When people hear about that, obviously feel very okay, guys. I'm going to be doing these videos. I'm going to be doing reaction videos.
So the top
Doing breaking down lawsuits. I'm going to be, day in the life videos. So this is, stay tuned. It was very enjoyable making this, and have a good day. Bye.